Ja, god morgon allesammans. Jag heter...
Good morning, everybody. My name is Anders Olin, and I'm going to tell you a little bit about what's been going on in Sweden since Reykjavik 2015. I'm going to do it in this way. So I'm going to firstly tell you a little bit about the new legislation that's in place, and then, thank you very much. And then I'm going to tell you a little bit about ongoing work, legislative work, and then also finally just go through what's actually happened, as it were, what's being done in practice. And I'm supposed to be doing this in 10 minutes. Anyway, as normally when it comes to copyright, EU law naturally comes before national initiatives. And for us, that has meant that in the last 2 years, we have been obliged basically to prioritize the implementation of EU directives, and naturally that has been therefore the CRM Directive that's been in focus. We have had some national initiatives, had time for that, with new act on mediation in disputes that pertain to this area. And also, what's very important, we have a new court order for IP and market cases, either new patent and market courts. And they've been up and running for almost exactly a year now. So let me firstly say a little bit about the new Mediation Act that came into force on the 1st of July this year. And that is linked to the Licensing Agreement Act, which is in fact the collective management licensing situation. We've, in Sweden, the parties in the market, if you can't agree on the conditions for a licensing agreement, then you can get help from mediators. And until quite recently, this has been an institute which is not very structured, and it's been the government that has appointed the mediator as well. This is something that has been changed now, so the mediator can be appointed by the court instead. And the new legislation also mean that the regulation here is more effective and stricter as well. So we've got clearer rules as regards the requirements placed on the mediators, and also different rules with regard to a deadline, for example, when negotiations shall be terminated. And in conjunction with this new Mediation Act, that number of amendments have been made to the authorization rules in the Copyright Act. Previously, we've got different authorizations, for example, for different types of books, audio books, etc., and archives and libraries. So a very important change then that has taken place during this period is the new patent and market courts. This means that all IP and market cases and competitive cases as well are to be dealt with in two special courts. The first instance is the Patent and Market Courts at the District Court in Stockholm, and the second one is the Supreme Court, the Patent and Market Supreme Courts. And this is something that we've been working on for a long time at the ministry. And the background is naturally that these types of cases are very, very complicated and very extensive normally. Also, there are not that very many of them, so it's been difficult to have a lot of knowledge and competence in these cases when they've been spread out at different courts around the country. So the whole aim of this reform is to ensure that we have a more effective process here in the courts. So the Patent and Market Supreme Courts that then takes on, for example, copyright cases. And the idea here is that's the final instance. The idea is to place a lot of responsibility with regard to what's done in practice on the Supreme Court. So these cases that are taken that far cannot be appealed. And then there's also a valve, what we call a valve, which means that the Supreme Court, Patent and Market Supreme Court, can itself decide that something may be, or the Court of Appeal that says that it may be taken to the Supreme Court. And the Supreme Court perhaps in the future will also then look into these matters, but perhaps to a lesser extent than has been the case up until now. As I said to start with, During this period, we have also compared the CRM Directive and incorporated. This has been done with a entirely new act, which came into force on the 1st of January this year. And another important issue with that incorporation is the new provisions, whether there be a supervisory authority or not, and the decision has been made that we need to have a supervisory authority for this entire act, and that is the Patent and Registration Authority that has been set up as the supervisory agency. So what remains to be done? Well, there are a number of public inquiries which are still ongoing, where we haven't actually, where nothing has come of them. We have, for example, the contractual copyright there, and then we also have the inquiry on follow-up law, for example, more stricter rules with regard to accounting, and which makes it easier to maintain your rights. And then there's also an ongoing inquiry on to see whether we need stricter rules with penalties when it comes to infringements, and that inquiry shall submit its report at the beginning of next year. So it's not just legislation that we deal with at the ministry. The government is also working with other ministries as well with regard to copyright and IP, and there we need to, for example, spread knowledge about the importance of copyright in the digital environment, for example, and together with other authorities, we are working to try to minimize the effects of piracy. So I hope I have a minute or so left just to look at what cases. As you can see here on this list, I'm not going to go through this in any detail at all, but I just want to say a little bit about each of these cases, in fact, these legal cases, and I'm just sort of very quickly mentioning them. The first one there has to do with fines. So it has to do with fines when it comes to copyright infringement, when it's a third party that has carried out the action. And the second one is, for example, has to do with sports broadcasting, for example, and what there we need to look at transmission of sports, and there we see that we need to ensure that the contents is extensive. I mean, more than just the match, for example, that is the result of a creative work. And the next one there, from 2016, and that is how art in public places, how that situation is determined. And the conclusion can be drawn that it is not permitted to have an open database and to have photographs of artwork which is placed in a public place and have that on the internet. And the next one there has to do with private or remuneration for private copies for mobile telephones. And in this particular case, we see that it's with regard to different devices which are suitable for private copying. And the next case from 2017 is a classic case of the processing and new independent works, the balance there between the two. This a photograph, for example, used as the basis of an oil painting, and the oil painting is a new original independent work. So there's a sort of or is it a process? Is it a further processed version of the original works? Then, as regards a more recent case, let me just mention that the court says that copyright infringement is not a crime which leads to a prison sentence, even if, and this is what we call different types of criminality. And then the final case there is from the patent and market case. This is something that has been discussed in the last few years, this particular type of case, the blocking of pirate sites. And here the court then says that according to Swedish law, it is possible to tell an internet provider that they block a site so that their users do not have access to such sites. So that's it for me. Thank you very much.